Yeah. Okay. Before the next question you're going to ask is the question about the nannies and the nurses and why their safety should be put in jeopardy, why they should be allowed to be put in, as we've established, cars that are unsafe for them. That is rather simple.
How do you know that's the next question we're going to ask?
Because that's the question that we spent the entire day of yesterday on, and Dean's going to ask it.
That exists in a separate page.
Shut up. So.
Yeah, wait, can we just ask
Wait,
Yeah, we're
we're
in charge of the court here. Objection, Your Honor.
I will also be held in contempt.
You can ask your question.
Stop wasting time.
To first state before you ask any question that if you happen to bring up the question
why are you waiting until we bring that up and then
Smell you later response.
Alright,
guys, time is wasting.
Okay, let's go to.
Alright, so we're gonna talk about Strouder versus West Virginia. Holly, you wanna?
Yeah, I mean, I think so part of the justification for segregation as being explicitly constitutional deals with some cases of school segregation.
Yes.
So you used some precedents from there, but it's, so I'm not going to, maybe we'll return back to those, but one of the things that you do also cite is the Strouder v. West Virginia case. And so I want to go into a little bit more of that and explicitly where it's found in that ruling that this kind of separation is constitutional.
All right. So Strouder v. West Virginia is not asking for separation. If you know the case, which theoretically you do, about the jury and how.
So actually, I'll ask my direct question.
Okay.
I won't. So the very idea of a jury is that it is a body of men, that's annoying, but whatever, composed of the peers or equals of the person whose rights it is selected or summoned to determine. That is, of persons having the same legal status in society as that which he holds.
Yes, thank you for reading that. Yes. So what we derive from that is that then a person on a jury is given the right to their peers, and that suggests that a peer of an equal of a black defendant is black jurors. So that would suggest that there's this general need that
so you can't have a peer who's white. That's not
that's
peer.
According to
so
this.
but they say a
person. You can have a peer who's white, but that doesn't like.
They can have a peer, but in the case of a needed peer and equal, according to this case, which is the case precedent.
Alright, so what are you using that to say in this?
So what we're trying to say is that according to a lot of school segregation cases in state courts, including like Roberts v. City of Boston, State v. McCain, People v. Gallagher, and many others that are all for state courts, which seem to suggest that the states in general already believe this, that the reason that there is school segregation and the reason why there's separation between different kinds of students is because of the needs one requires to have fulfilled. For instance, in the case of someone who has special needs because of a disability, they have certain needs that need to be fulfilled as opposed to someone who doesn't have said disability. So, Strouder v. West Virginia suggests that a
do black and white people have different legal? Do they have different legal status in the state of Louisiana?
No.
Okay, so then that is a person having the same legal status in society as that which he holds. That would mean that essentially that if white people and black people have this same legal status, then that means that that's the only thing that needs to be of the same thing, which would then mean that there isn't any separation.
No. Me and you both have the same legal status, but like that doesn't mean that, say, a government-run all-female school, I would not be allowed to attend. But that doesn't mean that we still have the same legal status, but those are things that are pre-established repeatedly by state courts that those are fully constitutional.
Yes.
But
So,
You're
if I
saying
understand,
because of the needs of the different races, there have to be different.
but that's not what Strauder v. West. That's
we
not
aren't
what
saying-
this specific piece of it. Their rationale for this is that they say that they define, this is the subordinate clause is explaining, that is a person's having the same legal status in society as that which he holds.
yes, however, it's saying that people who have the same legal rights and statuses don't mean that they have the same legal needs to be filled and that they.
I don't see needs. I don't see that terminology here. If you do find, like, if I find that, then I will, like, I want to see that.
I think what she's trying to say is that according to this precedent, black people cannot be determined as a separate peer group who have different needs because they have the same legal status as white people under the 14th Amendment. They are black people and white people, or in this case, black men and white men, are peers of each other.
But just because people are peers, doesn't mean that they're legally equal. That doesn't mean they don't have different needs. That's why we have homeless shelters. Like I as like a relatively well-off person who can, my parents can afford to house me. I do not have access to a homeless shelter, but someone who has the same legal rights as me, but who doesn't have the same position in society, who is economically worse off, they do have access to places like those, or to free schooling for the poor.
And if I may reply to Talia's question about need, within the Strauder v. West Virginia ruling, there is a statement of their training had left in regard to black children versus white children. Black children, their training had left them near children. As such, they needed the protection, which a wise government extends to those who are unable to protect themselves. They especially needed considerations. The 14th Amendment was framed in adopt. So there is a regard of need when talking about the question
Safety
of
under
those bills.
discriminatory laws which might separate them, perhaps, or do things that would
I feel
undermine
that
their
that is
legal
a bit
status.
of a extended leap from one to another, and
I mean, if this is going to make them inferior for the next couple decades,
we are not talking
I
about
wonder.
inferiority. We are talking about separation. Separation is
So-
not inferiority,
Okay, well,
not by definition.
what do you mean not by definition? Because I mean,
We have been trying to prove this whole time that it is possible to be equal alongside separate. So separation is not necessarily inferiority, as we proven by many a case, as well as the Federal Interstate Commerce Commission's guidelines on equality suggest that this is equal.
the federal, I don't know what that refers to.
None.
There's,
You serious?
Federal.
Yes.
we're going to get 2 extra minutes.
Only if, yeah, so if
Can we
the,
do 3 extra minutes?
you can do whatever you want. Yeah.
Whoa.
I feel yeah, 5 for both.
Yeah, why don't we say,
5 for both? We need petitioners to know they're coming to stand today.
Alright,
It says you guys
Petitioners didn't
are.
prepare anything.
Alright, we'll do 5 minutes more for both of them. We like to start with the respondents.
Wait.
Is that alright?
You do that?
Yeah, we can. Mr. Gadsden didn't pick up.
Why not?
we can do whatever we can do.
Mr. Gadsden, we do that?
We decide who wants to.
It is your court. As long
Alright, it's our board, we're gonna start with the respondents. 5 minutes.
It's fine.
Wow,
It is the judge's court.
I don't want to hear it.
Okay, please stop talking and wasting time.
Can you honestly forfeit 5 minutes after you even do that?
I did.
You're just going to destroy
Alright, you know what? I'm gonna make an executive decision, 3 minutes for each side.
What?
3 minutes for each side.
Starting and I can forfeit our time.
Hey, the judges have,
Jacob, please stop talking. Thank you.
Alright, so
I
let's start with you
think
guys.
he's
Alright,
gonna
so the next question that we wanna talk about is the slaughterhouse case.
More on.
Alright, happily.
More on the
I'm sorry,
slaughterhouse.
you would insult your own Supreme Court colleagues.
So we want to bring up the point that in the slaughterhouse case it says explicitly that
This part.
yeah okay 1 second. No, it's okay. Basically, what it says in the slaughterhouse case, the part that we're concerned with right now, is that in order for people to be able to carry out their work, or it could also apply to their education, it would be allowed to segregate, right? That's what it's saying. It sets up a standard for segregation when it violates someone's rights. And so if you can prove that the car does this, doesn't let someone kind of do their job or practice something that they need to do, then that would be permissible. But we want to know why this segregation is giving people that protection.
Can you repeat the
But it is not true that it deprives the butchers of the, is this the one?
Yeah,
you're
that's,
referring
yeah.
to? Okay, but it's not true that it deprives the butchers of the right to exercise their trade or imposes upon them any restriction incompatible with its successful pursuit or frustrating the people of the city, the necessary daily supply of animal food.
Yeah, so we're saying that this segregation on the trains in Louisiana isn't denying. There's no. It's not denying. Sorry, can you just respond to that quote that Talia just read?
1 minute
That
left.
quote, that
1
quote
minute.
I believe
Alright, give him
is
an
the
extra-
one in my.
Yeah,
Yes.
give him
I think
two.
it's,
That
An extra
quote,
2 minutes?
it could set up a standard
2
for
minutes.
actually.
it sets up a standard which is not, the quote itself gives the opinion that, the cities, that the monopoly that was given to the company is not in violation of the 14th Amendment when talking to the butchers. And the reason that it sets that up, later on it goes to explain that as saying that the butchers have not had their 14th Amendment violated because they are provided a space to work their trade in the grounds that the company owns. Therefore, they have a place that they could continue their business.
So there was
An allocated area.
so there was
where
an
they could do
allocated
so.
area where they were able to practice their right. Is that correct?
Yes.
Okay, so that would set up a standard then for if you're allowed to have segregation.
Yes.
So if your right is freedom of movement, then
Where's there a right of freedom of movement? There is a right.
there is a right to freedom of movement somewhere. There is, I promise you there is.
Just keep asking the question about like.
No, so if there is this right to freedom of movement, wouldn't that change? Wouldn't that perhaps say that
However,
segregation?
freedom of
20
movement is
seconds.
not an applicable thing because that would suggest then
Under the 14th
that I could use my right of freedom of movement to say, I don't know if they have the Pentagon, but like I could walk into the Pentagon and say, this is my freedom of movement. That does not apply in the same manner. Does that
So-
make sense?
No, if the standard, if I go into freedom of movement, I can prove that that's standard.
Alright, stop, and Eric, put the same amount of time back on, and give it, and 4 minutes, great, and give that time to the petitioners. Go ahead.
I think I
Alright.
Did you have better?
Ready?
I think I have
Oye, go.
My question is, what does the 14th Amendment mean? Does it mean equal access or does it mean equal treatment? And can you explain?
The 14th Amendment means equal treatment.
Okay. Can you explain, please? We're happy to answer.
It's a great question.
Yeah, so your question is when the people who crafted the 14th, or added the 14th Amendment to the Constitution. The slaughterhouse cases seem to say that the ruling said that the 14th Amendment means equal access because these butchers had access to a place to exercise their trade. So what the monopoly was doing could not have violated the 14th Amendment because the 14th Amendment serves to provide equal access. So black people have equal access to a train car given it is definitively not equal a train car, but it doesn't matter because they have access to a train car. They have the same amount of access as white people do. So that's one reading of the Constitution. I'm looking for another one because that one's racist. Give me another one.
Yes.
Yeah.
So well, addressing 2.28, we read the objective, or the writing of the 14th Amendment, and with that, the objective of the 14th Amendment is to offer protection to all the citizens of the United States of America. And with that protection comes equal access to all the privileges and immunities that every citizen has, that white citizens have, and as every privilege the white citizens have, as we believe homeless and black citizens should have as well. The holding in the slaughterhouse cases is that the 14th Amendment gives this protection, offers this protection to all citizens, and we believe that it's with this equal protection and these equal privileges, we think that if white people are given the privilege to a certain train car, black people should have the same privilege to that train car.
So the privileged equality to a certain
Yes,
quality.
that is absolutely a necessity in our nation.
Can you give some precedent for the idea that that you say in your brief, Izzy, that equal in the context of law means that every citizen has the ability to do the same thing? Although that may be a nice
Sentiment.
philosophical sentiment, can you give some legal precedent for that?
What's your?
I'm asking for precedent about the sentence "equal in the context of the law" means that every citizen has the ability to do the same thing.
90 seconds remain.
Right. Okay. Are you saying that precedent that's saying that giving blacks and whites both access to train cars, even if they're different, is not?
I think we're just asking. No, just asking about like where do you come up with this? You just.
I think that sentence
saying
may have been a little bit of an exaggeration because obviously not everyone like afford.
I'm
the
wondering.
same thing.
I'm just trying to understand.
Why? Because you make this big argument in your brief that equality means identical treatment, but why is that the case? Because equality to me just means the same level.
Thank you for explaining that. I understand your question. So my argument is I use precedent to come to that conclusion. That argument.
What precedent?
Okay, so let me explain to you that precedent. That conclusion that I arrived to in my brief is based on the fact that when blacks and whites are separated in the law, as John Marshall Harlan argues in his dissent in the civil rights case of 1881 or 1883, is that when there is this separation in the law and one group is favored within the eyes of the law, then this equality can't be reached. And until there is equal treatment within the law, based on the precedent.
But I'm saying that in this law, or I'm saying that potentially in this law, they're not favored. So
except the thing is,
why?
with the ambiguity that goes in when the
5 seconds
equal, you can't say that they're not favored because in the practice of the law,
I'm arguing.
Okay.
I'm arguing there is a difference in the law.
No.
When legislators decide that they need to.
Objection.
So, okay.
Can we add more time to see that?
No. So yeah, I'm gonna be William Rehnquist here.
Can we just answer the question?
William Rehnquist was a very famous.
Yesterday, and they're already up at 46.
Okay.
You know what?
William.
Get more time.
Sucked.
Okay. Okay. William Rehnquist was the Chief Justice. Please stop. Thank you. William Rehnquist was Chief Justice from the mid-'80s until he died in 2004, I think, 5. Was very famous for literally cutting off the petitioners and respondents at the moment that the red light went off. He would stop you mid-word if that's where you were at. Not all Chief Justices do that. However, I think that we're ready to move into the conferences. So here's what we're going to do. We are going to keep the justices that are here right now. You're going to conference. I'm going to ask the petitioners and respondents to go quietly, not talking. Go find yourselves a seat. And justices, spread yourselves around the table, and you'll begin discussing. So we're going to hear the conference of this justice group today.